Court is on the record in a civil action entitled In Re Failure to Obey Subpoena, Dakota Mullen, case number 25 MIS 10. The court issued an order to show cause on June 4th, 2025. The order basically reads that pursuant to Rule 17G of the Ohio Rules of Criminal Procedure, the failure by any person without adequate excuse to obey a subpoena served upon him or her may be deemed a contempt of the court or officer issuing the subpoena. On May 29, 2025, Dakota Mullen was personally served with a subpoena in City of Contempt versus Ann Headley, case number 25 CRB 105, ordering her to appear on June 4, 2025 at 1 o'clock p.m. at Contempt Municipal Court. The court did attach to its order a copy of that service return from the court bailiff indicating that service had been perfected personally upon Ms. Mullen. Ms. Mullen failed to appear on June 4th, 2025 pursuant to the court order subpoena. I then issued that order ordering Ms. Mullen to appear today, June 25th at 1:30 p.m. We're starting a little early, to show cause why she should not be held in and punished for contempt of this court for refusing to comply with the court order to appear on June 4th, 2025 in the Headley case. Ms. Mullen is present. She is not represented by counsel. Also present is Law Director John Lewis. Pursuant to Section 2705.02 of the Ohio Revised Code, specifically subsection C, a failure to obey a subpoena duly served or refusal to be sworn or answer as a witness when lawfully required is deemed an act of contempt. Pursuant to Section 2705.05, a hearing is required in all contempt proceedings. At that hearing, the court shall investigate the charge and hear any answer or testimony that the accused, in this case Ms. Mullen, makes or offers. If the accused is found guilty, the court may impose any of the following penalties. For a first offense, which this would be, a fine of not more than $250, a definite term of imprisonment not more than 30 days in jail, or both. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You are Dakota Mullen.
Yes.
Ms. Mullen, you were served personally with a subpoena by the court bailiff on May 29th, 2025 in the case entitled City of Contempt versus Ann Headley. Is that correct?
Yes.
You were ordered by the subpoena to appear on June 4th, 2025 at 1 o'clock p.m. Do you recall that?
Honestly, with all the subpoenas I've gotten over the past month and a half, I do not recall.
I don't want to hear that, Ms. Mullen. I don't want to hear it. She was the victim in the Headley case, right? Or alleged victim?
Yes, sir.
Poor excuse, Ms. Mullen. So I want to know why you weren't here that day.
I cannot,
Tell me the truth.
I truly cannot recall the day, but I'm sure it was probably a day where there was Todd's case the day before or the day after, or 2 days before or 2 days after, and I just mixed it up. I don't know. That's all I have to say.
I don't recall, Mr. Lewis, did Ms. Headley's case got dismissed, right? Because of Ms. Mullen's failure to participate or appear?
No, Ms. Headley's case we're having a hearing on it today, Your Honor.
Oh.
Yeah.
Maybe that's why I scheduled it
It's
today.
it's scheduled for a final pretrial today.
Okay.
Yeah.
What time is it scheduled?
1:30, Your Honor.
Well, Ms. Mullen, you're not going anywhere because I'm going to defer. I'm not going to take action on on the contempt until I'm assured from Mr. Lewis that you are actively cooperating with him. What your decision about how to proceed on the Headley case is between you and him. I'm not telling you you have to proceed in a certain way or not. But I am directing you to cooperate, and that's what a subpoena is for. You are to cooperate. You are to be here when you're supposed to be here. I will address the contempt proceeding here shortly, and we'll see what happens. So you can go back into the area where victims are normally located until Mr. Lewis needs you, okay? Okay. Well, we've had some experiences with you, Ms. Mullen, over the past month or two, and you've testified recently in another case. I can't remember which case it was, but it seems like you've appeared before this court quite often here in the last few months in different cases, and I just don't like your appearance. I'm going to hold you in contempt of court for failing to appear on June 4th, 2025. I'm going to suspend 30 days of jail. I'm not going to impose a fine. I will waive court costs. But I am going to order today that you submit to a urine drug screen. And I am going to, once I see the results of that urine drug screen, call you back into the courtroom, and then we'll decide to complete the sentence with respect to probation. Okay, so you're going to submit to a urine drug screen today. Anything further, Mr. Lewis?
No, Your Honor. Thank you.
Ms. Mullen, there will be someone who will assist you in that respect. Thank you. The court is back on the record in failure to obey subpoena in Dakota Mullen, case number 25 MIS 10. For the record, the court has been recording these past few hearings involving Ms. Mullen under the and heavily bookmark. So I made a mistake on that, but we're back in the courtroom to continue the sentence. Ms. Mullen is in court without counsel. Also present was Law Director John Lewis. When I found you in contempt of court, Ms. Mullen, I imposed a sentence of 30 days jail, suspended. I waived a fine. If over the course of the next 2 years you're found to have violated in any way the terms of your probation and sentence, in this case, you do face up to a maximum 30 days in jail. I could extend your probation from 2 years up to a maximum 5 years, and or I could impose more restrictive community control sanctions, more restrictive than what I've already done. So do you understand the consequences you face if you're found to have violated your probation?
Yes, sir, I do.
Yes, go ahead.
I was planning on going back to dancing at clubs, which I don't know if they serve alcohol or not. Am I allowed to?
Yeah, well, here's the way this court operates, Ms. Mullen. First off, a bar is a bar is a bar, and so when I order you to stay out of a bar, that means to stay out. Now, if you really want to make that request to me, I want to see a letter from the bar, or from, I should say, not a bar, I want to see the letter from your prospective employer offering you a job on their letterhead, and I want you to make a written request for me that you would like to be able to go to work there. See, we don't operate on speculation. I may work, or I'm going. It's not speculation. I want to see an offer, and then I'll consider it. And I'm telling you, depending on the place that I'm thinking you're asking me to allow you, it's probably going to be a no. But perhaps you might want to look at other more productive employment that's respectful of you and your recovery. Anything else, Ms. Mullen? Okay, thank you. This matter is concluded.